of Sociology. So when we were first planning this event, we had planned for it to be an information event as well as a sort of voting drive, so that's why you'll see the QR codes in front of you. And when we were researching, it said online that you could vote 15 days ahead of the referendum, but for some reason I think they've brought that forward, for whatever reason. So now, Eleanor, our Equality, Diversity and Inclusion Officer on the Law Society, will talk to you about the importance of voting. And then Jake, our conference convener, will quickly run through the process with you on the screen of how to register to vote. And then I will hand over the floor to our chair, Frank Clarke.
Thank you.
Hi everyone, so my name is Eleanor Schrader, and as Rowan said, I'm the Equality, Diversity and Inclusion Officer with our Law Society. I'm just going to speak to you briefly on the importance of education and engagement in our voting system and the role you can play in our democracy. So as we navigate our democratic landscape, the engagement of youth is not only desirable but absolutely crucial for shaping a progressive and inclusive society considerate of your values, needs and wants. Ireland, as a nation, is a society that has been drawn up from pivotal decisions that were made. From marriage equality to abortion rights, these decisions created the fabric of our society. However, these decisions, to be truly representative, active participation from you, young people, is vital. Young people are the architects of tomorrow. By actively participating, we have the power to influence decisions that make Ireland we inherit. It's not just about voting, it's about creating the future, our future. By voting, we ensure that our concerns are considered. We foster a more inclusive and representative democracy with policies and laws which reflect the entire population. Encouraging youth participation is not just about voting, it's about the culture of education to empower young people to be educated and understanding of the issues at hand. Education is the key to informed decision making and will allow you to make decisions aligned with your aspirations and values. As was seen in our last referendum in 2018, about 24% of 18 to 24-year-olds who voted that day stated they were confident that they understood what they were voting on. 24%. So with this, I ask you to please get informed. Please inform those around you, have discussions, enforce your values, and keep an open mind and stay kind. We are the digitally native generation, and we must leverage technology to eradicate ignorance. Misinformation is prevalent, and discernment is vital. In unity, there is strength, and when we come together, our impact is amplified. The collective voice is a powerful force for positive change, transcending individual differences and building a shared vision for the future of Ireland.
Hello everyone, it's great to see such a great turnout now at tonight's event. So as we heard from my colleague Eleanor here, voting is not only just an imperative part of our democratic integrity, but it's also a great way to shape the landscape that we will inherit for the future. I think she really captured kind of the essence of John Lewis, who said that the vote is precious. It's the most powerful non-violent tool that we have in a democratic society, and we must use it. The present allows us to decide our future, and as a young voice in today's society, it's crucial that we take part and we voice our opinion through voting. So in order to vote, we must first register. So I'm going to just run you through how to register and check to register. So to register, you will check checktoregister.ie. As you see here on the main page, referendum deadlines were actually closed yesterday for registering. So unfortunately, if you do register from here on out, you won't be able to register, or you won't be able to vote in the upcoming referendum, but you will be able to vote in referendums in the future. So if you haven't applied, you click apply online to register, and you have to enter your local city or county council. If you are a Dublin local authority resident, then you'll have to go to voter.ie to register to vote, and you'll have to enter your PPS number. Then after that, you will just enter the rest of your own personal information, click next, and your local council or authority will be in contact with you anew to know if you have registered in time for the upcoming referendums. So, if you have already registered, you can check your details or update your details here and check your details. Or if if you're under the age of 18, which I presume most of you aren't, you can pre-register for upcoming referendums also. Yeah. That is it really. It's a very simple mechanism. So I'll just hand you back now to Ronan before we get started. And thanks very much.
Thank you, Eleanor and Jake. I will now hand over the floor to our chair and our speakers.
Thank you very much, and I'm delighted to be here in UL. As it happens, I was just saying to Laura earlier that I chaired a debate in UCD last night, and it was about a different potential constitutional amendment being the proposed possible amendment to confer the right to housing in the Constitution. And in keeping with the spirit of tonight's information rather than agitation topic, I had a very neutral introduction last night, even though the participants in the debate were very much on one side or the other. And what it going to more or less say the same things as I said then, with a slight twist. I think the first thing, and this echoes, I think, an important point that Eleanor made. I think in general terms, the Irish people feel a greater ownership of and interaction with the Constitution, precisely because we get to vote on it a lot. We're up to well in the 30s of referendums on various constitutional amendments, some of which passed, some of which failed, some of which failed but passed the next time. We tend to do that when we fail. And therefore, there is, I think, a democratic legitimacy about the text of our Constitution in a way that perhaps doesn't apply necessarily in quite the same way in every other country. And given that the Constitution itself confers the role of the courts to both interpret and apply the Constitution, I think it's important that that ownership is there. It isn't just judges deciding what they think of a Tuesday about what should be there. It is what the people have decided to put there or not put there or change what's there, often in relatively recent time. And I think that adds a significantly additional layer, as it were, of legitimacy to the process. The next general observation might be to say, well, what do constitutions do? But in the round, they do two things. This is very high level, I suppose. One, they set out the institutions of the state. They specify parliaments, presidents, courts, the various roles they have, the interaction between them and the like. And often in a little bit of detail, though extra detail to be filled in perhaps by legislation. But the other equally important part of most constitutions, and ours is no exception, is that it sets out the rights and obligations of individuals, of the state towards individuals. It, I suppose, in essence, by conferring rights, limits the power of the state as to what it can do, or perhaps obliges the state in some circumstances to do things. And it's that element of the Constitution that we're, I suppose, directing our minds towards tonight. And one might say even that part does in itself two things. Sometimes it expresses aspirations, values that the country has. It says what we're about. It gives an indication as to what the developing feeling of the state is. And we have changed an awful lot over the last 50 years since I was, like you, a student. As it happens, I was one of those who was on the organising committee that opposed the 8th Amendment back in the 1980s, when, as the Irish phrase goes, it wasn't safe, fashionable, popular nor profitable to be of that view. And it was interesting for someone of my age and history to find nearly 30 years later that unfortunate defeat from my perspective in the 1980s being reversed by a further referendum. But that also shows that the Constitution is a living document. It changes. It means different things to different generations. And that again, I think, echoes the point that Eleanor made. It's going to be the Constitution for your future if it's mainly the Constitution of my past. And therefore it's your ownership of it that is important, because it will define the way in which the country goes if But as well as being sort of slightly aspirational, the rights conferred by the Constitution tend to be expressed inevitably in general terms. They don't set out the detail of what's to happen. The detail is left to legislation or administrative decisions or whatever. And it's left to the courts to some extent to interpret just how that's to work in practice. But there is no doubt that it does make a difference in terms of real results of real court cases as to the words that are in the Constitution. The Supreme Court has recently reaffirmed in the climate change case that the proper approach to developing the rights that are to be found in the Constitution, either directly because they're there in black and white, or inferentially because they can be derived from the values that are expressed in the Constitution, is to pay proper attention to the text. And I think that is important. It's not a narrow textual approach that you look up the dictionary to see what things mean. But it does confer value on the text precisely because the people have spent time thinking about what that text should be. And it can bring about real results. In the context, for example, of the debate about whether there should be a right to housing, there's always an issue about what are called socio-economic rights. Are the courts the right place to tease those things out? And there can be a great debate around that. But, for example, we do have one clear socio-economic right in the Constitution, being the right to primary education. And that has had a real effect. There were cases where people who, particularly those who needed, as it were, an added level of education because of their own particular position, were able successfully to bring court proceedings which at least in part relied on that. So it isn't just that the wording is aspirational, it can also have a real effect. People are given the right to access courts, to assert their rights. What's in the Constitution affects how the courts interpret those rights and can have real world results. And therefore, maybe, I suppose, in respect of any proposed referendum, my final observation, there are probably two things to think about. One is, what would you like the Constitution to do in whatever area we're talking about? What's the aim of amending the Constitution? Is that an aim you approve of, as it were? And then secondly, and often equally importantly, does the wording that is put forward actually achieve that aim? And not always so, and it's interesting that in these debates we have around Constitution amendments, there very frequently is a legal debate about exactly what the wording proposed will do or will not do. So I think they are the two broad questions that anyone considering voting one way or the other in a referendum needs to think about. What is it that we're trying to do? And does the wording, and do I approve of that or not? And does the wording that's being proposed more or less achieve what I'd like it to achieve, or does it not do so? And maybe there can be issues about, well, I'd prefer if it was better, but it's good enough. But also there may be issues about, well, will it actually do more harm than good to the aim that I have? What the answers to those are happily not for me. They're for you and everyone else who goes into a polling station in about 3 weeks' time and puts an X on a ballot paper. But they are important questions. There are questions that people need to engage with. And I think a session such as we're about to have this evening, which will give food for thought as to how you might answer those questions and how that might affect into which box you put your X when hopefully you do go into a polling station in 3 weeks' time. It will help you make that decision in an informed way. And with that said, we're going to have two different perspectives, not necessarily two different views, but coming from different professional positions. And we look first to the societal element of it, and I'll ask Dr. Carmel Hannan to speak to us from that perspective, and then we'll have Laura afterwards. Thank you very much.
Thank you so much, Frank, and thank you to the Law Society who have been so good at helping us around this event, who've been really supportive. So what I want to talk today to you about is the context of this, the societal context, and particularly in Limerick this is really important because in the last poll lots of people didn't know how to vote, and lots of people said they weren't going to vote. And it seems of all our referendums of late, there's a lot of confusion around this one. And it's not helped by misinformation and disinformation, or post-fact society, as some sociologists like to call it. So today I just want to lay the context of how society's changed and how families have changed and how the Constitution might reflect those changes. And it's exactly that Frank said, you need to think about what do I want to see and what are the words going to do, or how good are they. So a lot of people say the Constitution is reflective of our society. And a Constitution written in 1937, reflective of these sorts of families, the large Irish family. In sociology, there's a whole debate around this idea of STEM families. But social sciences say that was an ideal type. That the Constitution, even in 1937, was a defence of family virtues, the strong power of this large family, and an idealised version of family life. And so it stopped us short of thinking of the ways, even in 1937, the family wasn't harmonious. So it's not that the family was this ideal type at the time. There was lots of inequalities, and in particular gender inequalities. There was a diversity, so this idea of large families, STEM families in particular, wasn't representative of all of Ireland and all social classes. And there was conflict within families around inheritance at the time, around dowries and the farm. So Connell, O'Brada, Kennedy, lots of social historians have commented on this. So the period was described as one son inherited the farm, a daughter, two might get a dowry, which was a matched payment, and the rest had to fend for themselves. And a third of cohorts in 1930s Ireland remained unmarried. A third of young people at the time never married, and a third immigrated of cohorts at that. That was the choice. That was the inequalities within society at that time. And even those who entered a convent needed a dowry. So you'd have to question the way in which it actually reflected society at the time. Of course, now we don't talk about the family. We talk about families and the diversity of family types. And the Growing Up in Ireland study has allowed us capture the diverse nature of families. Even though still from an international perspective, we have a large number of two-parent, biological, married families. So most children in Ireland, 76% in the Growing Up in Ireland study, are from married two-parent families. We see a small number of step families and a growing number of lone parent families that are represented by lone mothers mostly, half of which come because of marriage breakdown or separation and divorce, small numbers from divorce, and the other half from widowed. So lone fathers' families, even in census data, are a small proportion of families within Ireland. So this snapshot says, look, the Ireland of today has a diversity. We don't just have married families, we have a diverse range of family types and relationships. But from an international perspective, our numbers cohabiting in step families is quite low. Limerick is an interesting case. So this is a headline we see all the time in Limerick. Limerick City has the highest birth rate outside of marriage. So we have a high degree in the last births statistics, about 44% of all children were born outside of marriage, but in Limerick it was nearly 56%. So Limerick City in particular is interesting because the diversity of family types is particularly strong in the city, and also people in the city in the last poll were the ones most confused about the referendum. They didn't know how to vote. The other thing we hear quite a lot about is the protection of marriage as an institution and the role of marriage. So the Constitution as it stands still has special care for the institution of marriage and to protect it against attack. But lots of social science research, including our own work, has looked at this. So this is differences in children's reading scores at age 9. And we're comparing cohabiting families to married families, separated, divorced and widowed families, and never married one-parent families. And the blue line says, yes, at first sight, that there's about a 10 percentage point gap. So kids in cohabiting families at age 9 are scoring 10 percentage points less on reading scores compared to married families. And this gets the headlines. This gets, marriage is good. It's good for kids, it's good for society. But once we control for the characteristics of those families, particularly the mother's socioeconomic resources, the differences are reduced to 0 or around 0. So the difference is not that marriage is some sort of magic wand that fixes things. It's about the resources within families. The second part of what we have to think about today is around the provision of care and caring in society. So we talk about what do families do? What's the role of families within our society? Who does what and has it changed over time? Are we radically different now? Do we see equality in caring? So one of the things the latest census data has shown is that there has been a rise since 2016 in the amount of unpaid carers in our society, post-pandemic society. And they define, it depends on the definition, but this is a very broad-based definition. And sometimes with the referendum debates, the focus is on very narrow definitions of care. But this is unpaid personal help to our support to family members, neighbours and friends with a long-term illness, a health issue, an issue related to old age or a disability. So in general, we are seeing around the gap between women and men has increased, but in general the numbers providing care in the last census are higher. Of course, it's care within the family, and one of the biggest challenges for us to think about mother's role or women's role within society and how much that has changed. And who is doing caring for kids, and what's the role of the state in terms of childcare? Well, Ireland's childcare costs are one of the highest in the OECD, and recent work by the ESRI highlights two things here: that we rely a lot on informal care, particularly in two-parent working families and one-parent families, and unpaid care and no childcare are quite high, but there's differences across our family types. What's most important about our care is this idea of the public good, the social good it does. And there's a large amount of social science research on this. And it argues that this care that's provided within the family is fundamental for society. Without it, society would not function. Lots of things wouldn't work. And about 45% of women and 29% of men in the latest study are engaged in unpaid care of children or adults. So high proportions of people are involved in care, but there's a gender divide in this. It's highly feminized, it's invisible and often undervalued, are unpaid and underpaid. But there's some changes occurring. So in young people in the Growing Up in Ireland study, you can see the gender divide isn't as strong. And also we can see that Ireland has the third highest unpaid work hours in the EU for both men and women. So what happens in the family, what families do is really important for the social good, or the good of society. And of people who like to put numbers on it, like economists, they've reckoned, the last report is that it's between 2 and 5.5 billion if you were to pay people for all this care within families, the caring work that happens within families. So that is the context, the two big issues. Who's in the family, what do they do, and how should they be supported? And I'm going to hand over to Laura now.
For to the Law Society and to Carmel for all the organisation done on this, and to our retired Chief Justice Frank Clarke for agreeing to come down and give those inspirational words to us about how important it is to engage with the Constitution. I'm going to try to explain what the Constitution currently says in these two areas that we're looking at. So looking at the care area, looking at the family area, and then look at potential impacts of the wording of the amendments if they are passed. And there's a huge amount to get through on this, so I'm going to try to not get into too much detail, but if anyone has questions on specific aspects after, we'd be happy to discuss those in the Q&A. So first of all, it's important that we start off with the existing wording of Article 41.2, because we often hear all of this stuff about the woman in the home, but it is important that we know what the Constitution actually says and what it doesn't say. So it does say, in particular, the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. The state shall therefore endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home. Now, people often ask, what was this article all about? How did it make its way into the Constitution in the first place? What was the point? Why was it put in there? And now, the guy at the very top there, Eamon de Valera, is the man who was Taoiseach at the time and who was responsible for our 1937, the Constitution that we currently have. We know this was an issue that was very important to him. Historians have argued that his own views on women and motherhood were very influential because of the fact that he was returned home to be raised by his grandmother while his single mother went out to work in New York. And we know from his personal writings that certainly that was very influential. He keenly felt the loss of his mother in his life. But we know also there are many more influences at play apart from that. John Hearn, who was the lawyer who wrote the Constitution, he was a comparative law scholar. He would have been very familiar with the European constitutions of the day, and there were aspects from those constitutions that spoke about protection of maternity. So there were influences coming from lots of different areas. We do know that the influence of Catholic social teaching was particularly strong here, and the wording that's in our current constitution is actually taken from a publication from the Vatican, a papal encyclical, which is called Rerum Novarum, which said that a woman is by nature fitted for homework. But again, many people ask, okay, so this is where it came from, but what was actually intended by putting it into the Constitution? And I've put up a couple of quotes that De Valera gave himself in the Dáil when the Constitution was being debated, when people were asking him these questions. What is this actually all about? What is intended by it? And we can see clearly from the quotes that there is some desire to give a symbolic recognition to mothers. On the question of whether that should then involve some form of economic support from the state, it's rather more vague. But he does give some examples. So apart from these quotes, he goes on later on and he says, well, if a man was getting some sort of assistance from the state, then I'd like to make sure that the state would get something in return, so some form of community service. But if a woman was getting assistance from the state, if a mother was getting assistance from the state, then she's already providing such a valuable service that I wouldn't require anything else in return. So there's a kind of a vague possibility that the state would have some sort of economic benefit there. But because of the fact that he says there at the bottom, how the state would do that is another question. We leave the methods open and absolutely open as it is right that we should. So there was a reluctance to tie the hands of the state or the executive there, because in our legal system, the government is the body that's responsible for deciding how funds are spent. So there was really this reluctance to tie their hands in saying that they would have to spend money in one way or the other. So while there may have been some vague idea that some form of economic right may have been envisaged, that was never made explicit in the text of the Constitution, and it was certainly never followed through by policy thereafter. Now, people always ask as well, what impact has this provision actually had in the courts? Has it ever been interpreted by the courts? What have the courts decided that it means? And really, this article has not come up very often at all in our case law. And the cases where it has arisen, it has mainly had a rather negative impact and a rather unusual reading of it, let's say, in the courts. And again, I'm not going to get into too much detail on this, but just to give one or two examples. The case of De Burke versus the Attorney General is a great example here, because this is the case that challenged the law, which had effectively excluded women from juries. Since 1927, women were basically not allowed to sit on juries. But the law was declared unconstitutional in this case, so it was struck down. It was a massive win for women in Ireland. But the judgment of Chief Justice O'Higgins is interesting because he disagrees. And he actually interprets women's exclusion from juries as conferring a benefit. So he said this is not about excluding women from juries. This is actually a benefit on women because their place is in the home. The Constitution tells us that ideally they should be at home. So therefore we don't want to be taking them away from their duties in the home. And that's what Article 41.2 tells us. So he used Article 41.2 in a rather strange way. And we've seen other unusual uses of Article 41.2 in other cases. So for example, in two equality cases, the Dennehy and Louth cases, the provision was used to justify discrimination against men in the context where you had social welfare payments, like for example a deserted wives payment that was being given to deserted wives but not to deserted husbands. And when this was challenged on the basis of equality grounds, the court said, well, this is not discriminating against men, this is a benefit for women. And they used Article 41.2 in order to do that. So we never really saw direct case law on the issue in Article 41.2 of a woman being forced to go out to work when she would really have preferred to stay and raise her children. But there was one case in the 80s which really looked in a lot of detail at the article and looked at what it meant and what it could do. And that was a case called L versus L. And it was a marital separation case, and the issue came up of the division of assets in the family home. And at the time, the house was in the name of the husband only, which was the norm at the time. We didn't have joint ownership legislation at the time. But there was a rule that if a woman had contributed to the purchase price of the house or to mortgage payments, that she could gain a beneficial interest in the family home. The problem for Mrs. L in this case was that she was a housewife. She didn't earn her own money, so she had been unable to make any mortgage payments or contribute to the price of the house. So she couldn't gain a beneficial interest in the family home. And the argument was made that this makes no sense given our constitutional provision, Article 41.2, because this appears to prioritise the role of the housewife and gives it such importance that it tells us that the state has a duty to protect this role. And then the idea that those who would take up that role would be put at a disadvantage in law makes no sense whatsoever. And in the High Court, Mr. Justice Barr agreed with those arguments. And he saw the situation as somewhat ridiculous that the Constitution prizes the role of the housewife, but yet the housewife is put at a disadvantage because she doesn't have independent means. She cannot contribute to the price of the house, whereas a woman who is going out to work, is earning her own money, can do that and therefore can gain a beneficial interest in the family home. So the working wife is being put at an advantage in that situation. And Mr. Justice Barr pointed out that despite all of this grand language in the Constitution, the homemaker was being put at a huge disadvantage, a much weaker position. However, and I should say Mr. Justice Barr used that then to allow for rights to arise out of Article 41.2, but the case was appealed to the Supreme Court, and the Supreme Court disagreed first of all, and it was pretty much a slapdown for Mr. Justice Barr. The Supreme Court seemed shocked by what they felt was the revolutionary nature of his judgment, because they said he had overstepped his role, because judges, in theory at least, are supposed to interpret and apply the law, but not create law. And the Supreme Court said that what Mr. Justice Barr in the High Court was doing was creating law. So they said this, you can't derive that right from Article 41.2, it doesn't currently exist, that he was creating a new right out of this, and that you can't do that, that's a breach of the separation of powers. And the result of this case really was that Article 41.2 became effectively meaningless. Practitioners didn't see any point in taking cases and using this article to make these sorts of arguments, and we never actually had any further litigation directly on the provision. There was a couple of cases to do with in the family law context, and actually currently before the Supreme Court there is a case which makes similar types of argument in the care setting, but it's not going to be heard until after the referendum, which is rather unfortunate. But it was dismissed pretty easily in the High Court, I should say, so it will be interesting to see what happens in the Supreme Court, depending on whether or not the amendment actually passes. But just to sum up quickly then, based on what we've seen in this provision and how it's been read in the courts, we can say with a fair amount of confidence that there is no right to remain in the home arising out of this article, and certainly no right to economic support. So it's not the case that the state would be forced to provide for a woman to stay within the home. And that's because the wording that's there, it says that the state shall endeavour to ensure. That's not very strong language legally. That means the state has to try. And that's not really something that's a legally enforceable obligation. One other issue in relation to this provision as well is that it's never really been made clear whether it actually applies to women more generally, mothers more generally, or is it just married mothers. Certainly in 1937 it was intended to apply to married mothers, and that's pretty clear from what we can see in the Dáil reports. But even as recently as a couple of weeks ago in the O'Mara decision, Mr. Justice, or Chief Justice O'Donnell did make that point that we still don't really know whether the article applies more generally, so it could be quite limited. And because it's been of no benefit to women, we've never had any of the statutory rights that women have, things like maternity leave, anything else, they don't arise as a result of Article 41.2. They are all statutory rights. There's never been any benefit which has derived from Article 41.2. And because of that, we've had quite a number of bodies which have looked at this over the years and have suggested reforms to the article. Now, none of them have ever suggested retaining the article in its current form. They've always suggested some sort of amendments to this, whether it's making it more gender neutral and keeping the language that's there, or making it slightly stronger. But our most recent recommendation on this was from the Citizens' Assembly on Gender Equality. Now, some people may remember in 2018 there was actually a referendum proposed to just delete this article and not put anything else in instead of it. But a number of groups objected to this, saying we hadn't really had enough of a conversation on whether we should replace it with something. And for that reason it was decided to send it to a Citizens' Assembly set up especially for this reason, to consider this. And they interviewed lots of different groups, heard from lots of different experts. You had 99 citizens and an independent chairperson. And in the end, they voted overwhelmingly to not only delete the provision that is there, but to replace it, and to replace it with what was referred to as a strong form amendment. So not one that would be purely symbolic, but one which would have some sort of impact. And the wording that was suggested was that the state recognises home and family life, gives to society a support without which the common good cannot be achieved. So retaining that initial recognition but widening it out. And then that the state shall take reasonable measures to support care within the home and the wider community. And I might just wait until the end to take questions, but the idea with this wording is that it was trying to walk a balance between providing something that would be meaningful but not transgressing on the government's power to decide how money is spent at the same time. Because with something like this, the argument was that the government could say what we're already doing is reasonable measures to support care. We're providing all these various statutory supports and so on. But also that it would be open to a carer, for example, who is struggling to say what you're providing is not reasonable, and that they would then go to the courts to say the state is not fulfilling its duty here because this is not reasonable because I am struggling. And then it would be up to the courts to decide whether or not what the state was doing was reasonable measures, or whether they were fulfilling their duty. And the Joint Oireachtas Committee that was set up to consider the report of the Citizens' Assembly, and this was a cross-party committee, they endorsed that wording, and they asked the government to move ahead with the referendum on the basis of that wording. Now that's not what we've been given. So here's the wording that we have been given. The state recognises that the provision of care by members of a family to one another by reason of the bonds that exist between them gives to society a support without which the common good cannot be achieved. So again, that's a broadening out of that original recognition of the work that women do in the home. And then the second sentence, and shall strive to support such provision. So that wording is very similar to the wording that we currently have, which says that the state will endeavour to support, and this replaces endeavour with strive. And there's been a lot of talk in the media as to whether there's a difference between these two. I think Ms. Justice Marie Baker said very recently that endeavour means to try and strive means to try it a bit harder. You can decide for yourselves whether there's any big difference there. But I suppose the key thing there is it's very similar to what we already have. If you're looking for a sort of a legally enforceable obligation there, it's going to be very difficult to find one. So if we look at what any of this would do if it was passed, the first thing that's really important, I suppose, to emphasise is that if this amendment is passed, it is not going to take away anything. It's not going to take away anyone's rights. It's not going to remove any recognitions, because you can't take away what you never had in the first place. And this provision has never provided any rights or benefits or duties or obligations or anything else. It has never done anything, really. So removing it is not going to take away anything. On the other side, it's probably not going to create any new legally enforceable obligations or rights on the state either. So for the people who are hoping that they can force the state to pay money in the context of care, it's very unlikely to lead to that either. The other thing is, and it has been criticised in this respect, that it recognises care only in the family context. So the Citizens' Assembly wording would have recognised care in the wider context, but the government have pointed out that it's too difficult because care in the wider context is often a commercial issue, so they're saying that they confined it to the family for that reason. Also, the article currently appears in our section of the Constitution about the family, and it was always about the family, so again you have to look at it in that context, I guess. The other criticism which is being made of it is that persons with disabilities are not recognised, and I know today there was a protest about that as well. Again, on the other side of that, the government, I think today, has come out and acknowledged that there may be a need to look at this as a separate issue. So again, you have the question of whether something like this is appropriate to look at in the context of care, or is it more appropriate to look at rights of persons with disabilities in the context of, let's say, a reform of equality law, rather than in the context of care. But this amendment does not do anything for people with disabilities. What it will do, if it is passed, is it will remove the gendered language and the implication that women, but not men, have duties that they're required to attend to in the home, because that is what the article is currently telling us, that women have duties in the home that they should attend to, and if they're going out to work they'd somehow neglect those duties, but it says nothing about the duties of men. And again, maybe that was seen as acceptable language in 1937, but most of the people I have spoken to about this, and indeed my classes, if we look at this every year, most people would agree that that language is not something that is acceptable for a constitution of today. And most people agree that that in itself is useful in terms of taking that out. But you have to ask if you're happy with what's being put in to replace it. So some people feel that the wording that's being put in should have gone further. So again, you have to ask yourself, are you happy enough to support what's being put in there because of the fact that it's removing language that we want taken out, or are you unhappy with the wording that's being suggested? I suppose at the end of the day, none of this is unlikely to have very much substantive legal effect. It is primarily a symbolic amendment, but that's not to say that symbols don't matter, because symbols do matter and are very important both in the Constitution and in other contexts as well. So I'm going to move on because we need to fit in the family amendment as well. So again, just to show you the wording of this. So we're looking at Article 41.1, and Article 41.3.1. So currently what it says is that the state recognises the family as the natural, primary and fundamental unit group of society, and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. Really strong natural law language there, protecting the family. And Article 41.3.1 then says that the state pledges itself to guard with special care the institution of marriage on which the family is founded, and to protect it against attack. So what the referendum is proposing to do is to add that little section in green into Article 41.1.1 to say that the state recognises the family, whether founded on marriage or other durable relationships, and then in Article 41.3.1 to take out that little section which says on which the family is founded. So the first question you might ask is, why are we looking to change this in the first place? What's the point of this? And the key thing here is that the current text of the Constitution, as you saw there a minute ago, only recognises the family based on marriage. Because of that wording that says on which the family is founded, and only 2 or 3 weeks ago the Supreme Court has upheld that meaning, that only the marital family is protected, despite some strong dissents from 2 judges. But that is what the Constitution means, that only the family based on marriage is recognised and protected. And what that means then is that the state is allowed to treat the non-marital family less favourably in certain contexts. Now, in the past in particular, this led to quite a lot of hardship. And this was before we had a lot of legislation which has balanced rights in these areas. It was before we had an amendment which gave children constitutional rights, before we had things like guardianship legislation for unmarried parents. And in a lot of these contexts now, legislation has balanced things out quite a lot, but some issues still remain. For example, unmarried fathers have no constitutional rights. They are not even recognised as fathers under the Constitution. The unmarried mother has limited rights. She has rights which are derived from the text of the Constitution, but that they don't appear in the Constitution. And because they don't come under Article 41, that really strong natural law language, they're not protected to the same degree. But the unmarried father has no constitutional rights whatsoever. So that is an issue. And also, because of the fact that only the marital family is recognised and protected, there's sort of this implication that the non-marital family is somehow less worthy because of that. So that is why it is being proposed that we widen out the definition in the Constitution beyond just the marital family, but to other forms of family as well. And the wording that the government has decided to put before us is that they will look at families, whether founded on marriage or other durable relationships. And now I know some people are worried again about this wording of durable relationships and what does this actually mean? And I suppose the first thing to note about this is that you hear people saying, why aren't they just putting in a definition into the Constitution? And that would be a really, really difficult thing to do. And actually it's usually not advisable to put something really specific into the Constitution, because you might be sorry afterwards. And we did see that with the divorce referendum in terms of putting in very specific time limits into the Constitution, and we had to go to the bother of having another amendment much later on in order to change that. So if you have things that are too specific in the Constitution, that can be dangerous. You're in danger of leaving out people. So it's actually much better if there's a concept there that can be interpreted. Now, who's going to interpret it? The first body that's going to interpret this is the Oireachtas, the government. So they're the ones who are going to determine the policy on this. Now, some people have asked, why don't they publish information which would set out what their concept would be of durable relationship, what might be included, what might not be included. That would probably be a good idea if they did that. That would give people some confidence, I guess, in knowing the types of relationships that would be included or not included in this concept of a family based on durable relationships. But then ultimately, it will be up to the courts to decide, again on a case-by-case basis, as cases come before them, where you have, you know, a family, let's say, that they're saying, well, we haven't been included in government policy on, you know, whether it's social welfare or whatever else as a family, but we do feel we are a family, and our family is based on a durable relationship. And they will go to the court, and the court will decide if it is a family that's based on a durable relationship or not. And the court is not starting from scratch here either, because first of all, that wording, the durable partner, durable relationship, comes from EU law, and the courts have already been interpreting that concept in Irish courts in an EU law context. So this is not something that's completely new, and there's a lot of precedent there. But there's also lots of precedent from ECHR law as well, which talks about de facto families and respect for all forms of family life and so on. And again, people will say, you know, why didn't the government decide to say de facto family instead of durable relationship? But you'd have the same issue. It still has to be interpreted. So it doesn't really make too much of a difference whether you're saying durable relationships, whether you're saying de facto family, or whether you're saying all forms of family, which is what I think the Constitution Review Group suggested back in 1996. There's still always going to be a need to determine on a case-by-case basis what is a family and what is not a family. Just to note, the Citizens' Assembly did consider this as well, and their wording was that the state pledges itself to guard and special care the family, including but not limited to the marital family. So they wouldn't have had the words durable relationships in there, but you would still have to define family in this context. So again, it leads to the same thing ultimately in the end. So the potential effect, again here it's important to note that it's not going to remove anything, it's not going to take away anything, nobody's rights are being taken from them if the amendment passes. There is still a special protection for marriage. That is not going to be taken out by recognising other forms of family. That line in there which gives marriage special protection will remain in there. What it is proposing to do is to allow a wider variety of family forms to be recognised under the Constitution. Where you have a single mother of a child, they will be a family, just the same as two married parents and children are a family. Unmarried fathers can gain constitutional rights because they will be recognised as a family. It's not going to impact in any major way on existing policies. I've seen a lot of discussion in the media lately on things like immigration and even succession law, but again, these are mainly issues of policy, and they're mainly issues that are dealt with in legislation. And they're issues which have not been affected by things like civil partnership, so it's unlikely that they're going to be impacted in a major way by this change, if it happens, this change if it happens. And people are worried about, you know, issues like family reunification and immigration law and so on. Those things are already possible. Even without having an amendment on the family, it's still possible for people to apply for various different forms of families to be brought in under family reunification. So it doesn't really impact in the way certain people are arguing on issues like that. And the other thing is that the state, even if this amendment passes, the state will still be able to treat marriage more favourably in certain contexts where there is a legitimate justification for doing so. So if it's decided as a policy issue that it's important to prioritise marriage, they may be able to do that if there is a legitimate expectation, but certainly it's not going to take away from marriage or any existing rights that are there. So I'm going to leave it there, but I'll be happy to take any questions if you have them.
As we've indicated, there's now time for questions. Throw it open to the audience. People feel they know enough. You may know enough, but if you don't know enough, now's your chance to know more.
Has the state said anything about any potential support we could give in the future, or is it just the discussion of changing the article first and then implementing something into the state?
Well, they have indicated that this is something that they're going to build on, but I guess that is a policy decision that governments will make, so governments can make these promises. It's not something that the Constitution will be dictating,
but it is something that the government has said that they will do.
If you vote yes, are you voting yes for both amendments, or can you vote yes for one and no for the other?
You can vote yes, yes, no, yes, yes, no, no, no. There's myriad of possibilities
Or
there.
vote on one and just abstain on the other, but
Yeah.
whatever you like.
Exactly. So they're two entirely separate amendments.
Has there been any indication from government as to why they changed the proposed citizens' assembly burn? Or is it literally just because they don't want to pay?
I think it's pretty much that, like De Valera back in 1937, they didn't want to tie the hands of the executive. There may have been this fear that by putting something like that into the constitution, that maybe it was a little bit too demanding of the state, and they might have been worried about where that would lead and how much it might cost. Whereas putting something that's mainly symbolic in there, that gives them the power to decide when to spend and how much to spend. But you'd have to ask government. I
There's
suppose.
always an issue, I think, too, about constitutional provisions that require expenditure. For this reason, a court case, which is how it had happened, only involves the voice of those who are saying money should be spent on this. Obviously, there's a limit to how much money there is, so if more money is spent here, it can't be spent somewhere else. And while in a very imperfect way, politics kind of measures those and people make their case to government and government decides where to spend. One of the issues that's said that makes courts not ideal for dealing with these things is the voice of those who might want the money spent somewhere else doesn't get heard in the court case. It's just the people who say money should be spent in this particular way. Now, you know, there are constitutions such as the South African that does have a lot of socio-economic rights and which puts a kind of a floor, and the world hasn't ended. So, you know, that argument isn't a slam dunk, I think, but I suspect it may be part of that. There's a reluctance to have the courts as the place where the budget is decided.
And it would be a huge budget. That's the thing. This is massive amounts of invisible work, mostly done by women in all aspects of care. So when you start, and like other countries support it through policies a lot more, Ireland has started to change, but it would be a huge budget. And I suppose you have to think of the symbolism of it as well. Is strive or endeavour enough? Is that good enough?
Up at the back, yeah.
Do you think that the article like excludes the lack of governmental support for carers outside of family carers? Like, do you think that the article as a whole does more damage by putting onus of the duty of care onto families?
You mean the proposed amendment?
Or both?
Does that damage? Does it create potential problems? Is it by placing?
I think the original article already put the onus of care onto mothers and families.
Yeah.
But do you think that that whole concept takes away the duty of government to care for people?
People have made that argument, but again, there's a limit to what constitutions can do and can't do, I guess. And governments can decide on a policy basis if they want to support care, if they want to do this. The idea in the constitution originally was that you were just recognising and acknowledging what mothers did in the home. What this amendment is proposing to do is to continue that, but just widen it out to care within the family more generally. I don't think it's necessarily going to do any damage by doing that, because you're just widening out a symbolic recognition that's there in any case.
But Ireland, compared to other countries, has a really strong, places a strong role on the family. You know, that it's protected. We rarely interfere in the duties of a family. We won't, you know, the family's some sort of protected sacred haven where all of this care is supposed to happen, you know. And it's similar to other countries who have a strong Catholic background. So it's not unusual in Ireland to see the family as this resource. But it's also, you have to say, well, do you acknowledge what happens within the family? The amount of care that goes on for all sorts of members of the family, and how important that is for the rest of society.
Is the most symbolic thing then for people to do to abstain from the care amendment?
But
rather
again,
than
that
voting for, rather than keeping it as it is and putting the onus voting no and broadening that, just abstaining and saying we want better and more.
So I can see that argument, and that'll be a personal decision for everyone to make as to whether they want to do that. One thing I guess just to bear in mind is that by voting no, that's not necessarily going to lead to anything better. What we've seen in previous referendums is voting no as a protest has led to nothing. You're just left with the status quo. So I suppose again you have to decide yourself, am I happy if I vote no and then we're left with what's there? Or do I think voting no could lead to some sort of agitation for further change?
Yeah, that's what I mean, yeah, so if we're going to abstain on the care amendment, does that say that we give a shit, I suppose, about people with disabilities or people who need care or carers themselves, rather than saying the onus is on families in the community? It's to say the government needs to go again on this.
Well, if you look at the Shannon referendum as an example, most people voted no to abolishing the Shannon because they wanted the Shannon to be reformed. And that was a key message in the campaign, that we're not happy with the Shannon as it is, but we really want it to be reformed. We don't want to lose it, we want it to be reformed. So we're voting no because we want a new, reinvigorated Shannon, and absolutely nothing was done after that.
That's really, I think, a judgment call. You know,
Yeah.
what happened. In one sense, you could regard an abstention as half a no vote. You know, I mean, ultimately the vote counts, and the yeses are counted and the noes are counted, and the people who don't vote don't count in that sense. But it's really a judgment call about what do you think would happen if it isn't passed. Is it likely, as a matter of political judgment, that there will be another referendum with what, from your perspective, might be better wording? Or are you actually leaving the current wording, which you don't agree with, in there for a long time? That's a judgment about what's going to happen in politics, not legal or sociological, I think.
And referring back to Chief Justice Clarke, do you think that the wording is effective in the goals it's trying to achieve?
Which wording is this now?
With both of them.
Are you asking me that question?
You're the lawyer.
So I guess you have to ask, what is it designed to achieve? On the family, I think it is effective in what it's designed to achieve. So because the whole point is to open up recognition in the Constitution to other forms of family. I think if this wording is passed, it will do that. In terms of the care referendum, again, if what it's designed to do is to provide recognition more generally for care in families in a symbolic way and remove the gendered language that's currently there, it achieves that purpose, if that's the state of thing.
But the corollary is, if the aim is to actually put in
To
a higher
go
level of
more.
right for carers, it doesn't
It
do
doesn't
that.
achieve that.
So it depends on what the aim is. If the aim is one thing, it does it. If the aim is two things, it doesn't do both of them. I think it'd be fair to say.
Exactly.
Just out of curiosity, I'd be interested to know how you feel about the political parties, as parties that are pushing the yes vote and that kind of stuff. What would you think about that? Because I know there's precedent before about the government not getting involved in pushing for a yes campaign.
Yeah, so the McKenna case is a little bit different because at that time there was no referendum commission, so you would have had, obviously the government is the only one who can propose a referendum, no one else can propose a referendum, so they're always hoping that they're going to vote yes because they're the ones proposing it. And what you're referring to there, that McKenna judgment was back in 1996 when governments would have spent large amounts of money on the yes side and nothing on the no side. And Patricia McKenna argued that this was unconstitutional because you had huge funds going on one side and potentially nothing on another side. And the Supreme Court decided in that case that that was unconstitutional to spend public funds on one side only of a referendum. And so that's when you had the Referendum Commission. We now have the Electoral Commission that is set up. So that precedent is still there, that you can't spend public funds on one side only of a referendum. That's why money is being pumped into this. Political money is different. So political parties are allowed to campaign on one side or the other. So that's perfectly legitimate for them to do so. And even organisations that are supported by government are also able to campaign on one side or the other as well. Even though I know questions have been raised about this kind of thing in recent days as well. But it's perfectly legitimate to campaign as long as government money, state money, is not being spent on one side only.
Thank you.
Do you think that it could be a valid fear that by passing the care referendums it's going to be worse, that we might be closing the door on like what more do we need to do, or do you think that's not really a valid fear?
I think that's the same question here really, it's a personal decision I guess that you have to make. Do you vote yes in the hope that you're spurring on a movement that will lead to something else, or do you vote no in the hope that government get the message and realise people want more? That's kind of a personal thing I guess for people to make.
It's the same political judgment, I think.
Exactly.
If you vote yes, you might find the government says that's grand, we've done that, we don't have to worry about that anymore. Or you might find that they just, if you vote no, they say, well, there you go, we're not going to come back at this.
But there's also the voices of the groups, like the disability voice is very strong. And are they going to be silenced by a no, is the question, is that it? And I don't think so. So campaigning as well is really important.
It will be interesting to see if governments say more now about what they said today, about potentially following up with looking at disability rights more generally in their own context.
As a separate matter.
Yeah, that would be interesting to see.
Yeah. Should we be concerned about the fact that single parent families aren't going to be included in the durable family?
Oh, they will be.
So they are considered part of the durable family.
Durable
it's not just-
relationship.
Oh yes, definitely.
Someone up there?
I'm just wondering, just within the Constitution, obviously there's this concern if the care referendum is passed, just in terms of the rights of disabled people. Is there any other articles in the Constitution that would recognise those rights and that could be contested in the courts?
Well, we do have an article on equality more generally, and again, I suppose there are problems with our equality article. And one of the recommendations of the Citizens' Assembly was that we should also look to reform our equality article. The problem was the Citizens' Assembly didn't actually consider that as an issue. So they didn't have hearings on it, they didn't hear from experts in the same way as they would have on Article 41. So while they made a recommendation to say we should also reform equality, they were only looking at it from the gender perspective. And the government, I think, very wisely made the decision not to go ahead with a referendum on our equality article, because there's actually a huge amount of work that would need to be had before we could decide how we would look at our equality provision. And I mean, for years, sorry, Mr. Justice Clarke, but the courts have been very poor on equality.
You're not wrong.
Up until very recently, I mean, the O'Mara decision is
a big
potentially a sign of a complete change from the courts. And I know, Mr. Justice Hogan, for one, has always been very strong on the equality. Many of the judges that are currently there seem to have a different perspective on what the equality provision is capable of doing. So, I mean, we may see more development in the case law on equality. I think we probably still need more reform of our equality law more generally. But I think certainly, like, disability rights are already recognised in that context. But certainly a lot more could be done there.
With this article, does that supersede the equality article on it?
No, so they're very different. Yeah.
It wouldn't diminish whatever is there at the moment,
Absolutely.
however imperfect that might be.
Yes.
But it won't make it better either.
No.
Shane has a
Sorry. Yeah, so I was going to ask someone else has kind of already asked it about the durable relationship being one for a single parent, between the parent and the child being included in that. So probably I'll just make a comment from what I think you've been kind of saying about, if you go for a yes, all the things about kind of disability rights and how much money people get, you get the opportunity probably within the next year to vote for parties that will, to change the government, or vote for parties that will interpret things or give provisions of money and support to those, to disabled people or to families or wider families or to carers. You get the choice of electing a government that will, or parties that will support that to different degrees of your choice. So
politics student, you see.
Yeah, and it's a good point, because these are ultimately very political issues. So, and that is why, again, our vote is really important, both in the context of constitutional amendments, but also in terms of electing our next politicians, our next Dáil and Shannon.
And remembering what they promise.
No, I was really fascinated with the rights of the unmarried fathers. Is
is going to be part of that, I think that would be a big yes for me, to bring in this legislation because they have no rights now.
Well, they have rights through legislation. So
okay.
there are various pieces of legislation that give rights to the unmarried father, but the Constitution
Yeah,
does not recognise
I think that's
the unmarried father.
important, I think.
Yeah.
Have we any more questions? Or does everyone know enough? Oh, sorry.
Just one observation, just in terms of the role of the unpaid care in the home. My understanding is, I think it's the ESRI cost that it was like in the economic sphere within neoliberalism.
Yeah.
But that would be estimated to be costed or salary base of 55,000 a year. Is that political will issue? So I know in terms of the symbolic element of the referendum, a lot of other narratives I think aren't being amplified. Another element might be, my understanding is that 20 to 25% of unpaid carers in home are actually minors, they're under 18, which is also in the realm of massive child protection issues, where school-going children from home to minors or cared for an adult parent.
Yeah.
And again, there's lots of other marginalised issues in the context of the care referendum. I'm just wondering if there's any potential thoughts on that.
Yeah, the ESRI have been great at talking about caring within kids, caring within families, taking on caring for people who need it on a range of items from the recent report only about 2 weeks ago, so that there's been a lot of focus on care amongst adults, but that children are providing care, and of course this is a long history in Ireland. There was a whole debate of, people had kids to work on the farm and whatever, so children provide labour, invisible, unacknowledged labour as well. I think it's not just in Ireland, it's quite easy to ignore these aspects, because if you start to address how much benefit they are and start to cost them, so like there's a lot, they should be included in GDP estimates, they should be, there's a lot of massive campaigns to say, let's acknowledge the care work that's been done, at least acknowledge it in official statistics, not even pay for it, just acknowledge it, and that hasn't happened here either. So there's a real block, there's people fight for this all the time, and you don't see it.
That's more legislative rather
Yeah.
than
All right.
institutional.
And you also have the growing question of the care of mature children for their parents.
Yeah.
An ageing population increasingly has parents who are being minded by 40, 50, 60-year-old who just feel the world has got better because their children are off the books and now the parents come back on the books.
And a lot of them still.
My children are complaining about this prospect.
Yeah, and then it's exactly what you said in neoliberalism. Alternative to it is to privatise it. Privatise care homes, privatise childcare, privatise, and then who can afford it is the big issue, because it's really costly in the Irish case.
There is one of those interesting questions about GDP.
Yeah.
If you go and get someone to do it for you and pay them, it does form part of GDP.
Yeah.
If you do it yourself, or if you have two people, if I mind yours and you mind mine, and we both pay each other, we increase GDP. So if we both mind our own children, we don't.
That's a good point.
But you could set up a system where you notionally do it and set the two sums off, I'd say, return it to the CSO.
One at the back.
One at the very back there.
And there's one more here.
Okay, sure.
If they were first,
Yeah.
No, go ahead.
as a caveat, I'm not even Irish, so I can't believe I can vote in the referendum, but from what I understand, you guys are asking young people to care. Am I correct in that assumption?
Yeah.
Understandable?
Yeah.
I'm very much trying to. I'm trying to place myself in the position of an Irish voter around my age, and I'm thinking, would I care? And honestly, my answer is no. Because I'm desperately trying to find some way to see how this would leverage real change, and I'm not seeing it. And there was this question earlier of this person who asked, like, hey, if I would safe, or if I would know, how could I possibly hope that there's any different referendum or different wording that would actually hold anybody accountable? There's not. So it's, call me disillusioned, call me cynical, but I don't really see a point. But again, I can't vote on this thing.
Well, I guess it depends what you're expecting from it, you know. So, I mean, let's say going back to 2018 and it was proposed to delete the current article from the Constitution. And I think most lawyers were quite happy with that, saying, yes, let's get rid of it, it's done nothing, it's achieved nothing, it's insulting, we'll just get rid of it. But then you had the National Women's Council of Ireland and you had various care organisations, and they were all coming out and saying, actually, even if it's just a symbolic recognition, that matters. And I was part of the Citizens' Assembly again, and there was quite a number of carers groups and carers organisations, and they were all saying the same thing, that even if it's only symbolic, even if it's not leading to anything, this matters to us. Now, as a lawyer, I was finding that a bit hard to process, because I was saying, well, surely it should lead to something. But they felt that it did matter, even just having, like, symbols matter to people, and having this idea that this reflects what our society believes, that can matter to people as well. But even in a more concrete basis on the family, that matters even more to people. That if you say, if I'm a single mother of 3 children, and I say, well, I'm not even recognised as a family under the Constitution simply because I'm not married, that matters to people in that context. But even more than that, as we saw in the O'Mara decision recently, there are certain contexts where the marital family is given benefits that the non-marital family is not. And this then is an attempt to equalise that. So that can have concrete benefits.
There's one more question over here.
Hi, so I know that you said that it would be up to the judge to decide the definition of joint relationships. But how do we as people prove that we are in a joint relationship? Because I mean this in the nicest way. I looked up the ECHR's definition. It said intimate. What would that Sorry.
Yeah, I suppose that's to remove the possibility of just being good friends. Or saying it's just good friends.
And that would put a time, we'll say, and we don't want to put a time because we made that mistake with the divorce. But I saw that there was 2 years if you were married, 5 years if you weren't. That's odd, don't you think?
That's the current law, as I understand it, that you get sort of rights that aren't quite the level of rights within a civil partnership or marriage, but if you've been cohabiting for that length of time. I mean, there is always the problem that if, in practical terms in courts, there has to be some boundary. The fact that you set up a house together yesterday and broke up tomorrow, does that give you any rights? You know, and there's always an artificiality about some time limit. You know, you're 1 day short, does that mean you're out? You're 1 day over, does that mean you're in? But there have to be some rules to decide who has rights and who doesn't. And at the back there.
I suppose I think a lot of the no vote for the families being framed around removing parental leave and stuff. Do you think that's just blatant misinformation, or like why is that happening?
I'm not sure where ideas like that come from, because that is completely wrong. Things like maternity leave are statutory benefits. They come from legislation that is absolutely not going to be changed, whether we vote yes or no in that referendum. So, like, I'm not really sure where this information comes from. One thing that's really unfortunate is that the Electoral Commission will be given powers to actually deal with misinformation, but that section of the Act which sets them up hasn't been commenced yet, which is extraordinary that we're going into a referendum and they don't actually have the power to deal with this kind of misinformation. So I guess that's why it's really important for citizens to be able to inform themselves, but from sources that are actually reliable, so not TikTok. And everybody's getting these through the door, and they have a website, and that's the kind of information that you can believe when they tell you what the information is, you know.
Yeah, I think there's something as well about motherhood. It's so there's a you know, people feel that mother has been reduced or removed from the Constitution, and the role of mothers is going to change because of this. They see it as like denying people the right to work in the home, but it's not doing that. So you see all these campaigns. I love the poster with, you know, a woman is emotionally attached to the kitchen sink. She can be attached to the kitchen sink. No one's telling her she can't, you know. But it's that spin that's been put on it that's the danger. Yeah.
Oh, sorry, sort of off topic, but when you say the Electoral Commission being powers to combat like disinformation, has there been any sort of discussion about what those might be? Is that just sort of common arrangements?
Sure, actually. I think some of the social media companies have been having discussions about that today in select committee, but I haven't heard the detail of what exactly is involved. And I presume it would be that they would have to, you know, if information is spotted online that is wrong, that a directive could be issued to the company to say you have to take that down. But I'm not sure what the ins and outs of that are.
I was just curious.
Sorry, you might not be fully involved yet, but how does that interlock with free speech, would you imagine?
That's for another day.
Maybe that's why it hasn't been committed. Maybe there are small details to be worked out of that. But I guess if it's information that's incorrect, then there's a legitimate reason for preventing it from getting out there.
Yeah, I mean, there's two layers, isn't there? There's correcting it, which doesn't interfere with free speech. You can keep saying it's wrong, but I mean, what's wrong? Well, we're going to keep saying that you are wrong to say that. That certainly doesn't interfere with your right to say it, even, and if you don't care what the Electoral Commission says about you, that's fine. Taking it down is a bit different, but we do take down lots of things now. Maybe not enough, but we do take things down. Commission the Man is going to have a role in that regard as well. So it's the boundary really is the issue there. Perhaps we've sort of got to the end of the day, but I think it's been, from my perspective, a hugely interesting debate without adversarial nature to it. I hope people are better informed, whether that leaves you saying, I'm not voting, I'm voting yes, yes, no, no, yes, whatever. At least it's a good thing if you know what you're doing when you go or don't go to the ballot box in a couple of weeks' time. And can I thank the Society for organising this. It's been a real pleasure to be here.